LIEnette actually showed up for her bankruptcy hearing, and Saran Wrap threw that toothless fat FLEASA under the bus. FLEASA, who is hoping and praying that this federal bankruptcy lawsuit will save her. Oh, but there's no saving that thick walrus hide. We had multiple hearings in regards to bankruptcy court in federal court today with a brand new judge. The old judge has retired. A new judge is taking on a tremendous amount of caseload from the old judge. Now, things were supposed to start at 10:30. That doesn't mean our hearing is at 10:30, because what happens is they stack a whole bunch of hearings all together, and everybody comes in and they go, all right, this one first, this one second, this one third, this one fourth. And that's what happened. There were quite a few hearings before ours. And here's what my assessment is of this judge taking on these new caseloads. She wants all the details, boom, smack dab in her face like that. Time, information. She does not want to have to read through pages of anything. She wants it, the cliff point, here it is. I don't have to read through everything. I have a tremendous amount of work. I need to get it done. Give me the bullet points. Could even be square bullet points. But we're going to get to all of that. At 10:19, I enter on Zoom. Yep, I'm there on Zoom. And at 10:22, guess who I see in the Zoom? LIEnette! LIEnette of all people! She's finally decided to show up at one of her own hearings, despite running out of her last deposition, which she's now on the hook for sanctions, legal fees, and everything else. I also notice another friend inside the actual Zoom room. That would have been Madam Mayor Therese. As a matter of fact, they actually call out, hey, is there anybody else here that wants to identify themselves? And Madam Mayor Therese says, yeah, I'm here. I am a creditor. And in regards to LIEnette, Lacey, Alexis, Michelle, LMNOP, you figure it out. She couldn't even figure out what her name was in her deposition. Madam Mayor's there. At 10:27, I then see one of my co-counselors in the federal bankruptcy court, Dennis Levine. He shows up. And I'm thinking, is Randy here yet? But don't worry. Randy doesn't need to be there until 10:30. Which then at 10:28, I see Kevin, who is the lawyer for the trustee, who's in charge of seizing all assets, selling all assets in the bankruptcy court. Now, Kevin is specifically going to be mentioned by Saran Wrap as Saran Wrap implodes FLEASA's lies. We'll get to it, I promise. At 10:29, Randy shows up. Right before then, I look at how many participants are in the courtroom. There's 28. I notice some names. I notice a Carol. I notice some Mark. I notice some others. No doubt, beautiful people with beautiful hearts that want to see beautiful, poetic justice served. And at 10:29, once Randy's in there, what happens is the individual who's in charge of coordinating and hosting one of the courtroom staff says, all right, what case are you here for? Speaking to Randy specifically, Randy goes, well, we're actually here to be heard on 3 different issues. You see, we had quite a few things that were stacked up, like Saran Wrap's motion to dismiss. You think that went through? You know, because we're calling LIEnette out on fraud on the court, not actually sharing with the federal bankruptcy court her real assets, trying to hide assets, not being truthful, honest, not even giving discovery over. Oh, yeah, that was talked about as well today. Once our actual lawsuit, our hearing is called up, what happens is a roll call. They've got to know who's representing who and what's going on. So the judge comes to the front stage, to the podium, to her seat, and calls up and says, I'm on for case number 25. It's 2510-173. and a second motion to compel 129, and an objection to debtor's claims of exemptions, docket, I think that one was 26. There's so many papers going on and so many things to be heard right now. It's a little bit much for me to keep up with everything because I have a full life of other things that I need to keep up on. So what happens is they roll call, and what basically happens is they say, who's here? And so for appearances, Saran Wrap says, I'm Jerome Saran Wrap. Obviously, he didn't say Saran Wrap, but we do that to protect the guilty. All right. So Saran Wrap, I'm here on behalf of LIEnette Preston. And then my co-counsel. So keep in mind, I brought in a specialist lawyer for creditors in the bankruptcy court, Dennis Levine. This is his specialty. This is what he does. He is co-counseling with Randy Shockett. And so Dennis says, hey, I'm here on behalf of the creditor, Jeremy Hales, as well. And then we have Randy Shockett. I'm here on behalf of the creditor as well. And then we have Kevin. We have Kevin, who is representing the trustee, and I can't even say his last name, but he's representing Therese Bender, who is the trustee. Again, his job is to secure, to seize all assets, sell them. They get a percentage of that, and then the creditors get paid out from that as well. So basically, in a nutshell, there's a roll call, and then the judge says, okay, we've got a lot of things going on today. So basically, she said, we went ahead and we called the duplicate things for this hearing because we're going to do it all in once. It's going to be efficiency of the court time to do it all together. And she then states we're going to go on the debtor's claims of exemptions first, okay? So remember, LIEnette's the debtor, I'm the creditor. She's claiming she's exempt because of homestead from the federal court seizing 1.66 acres of turd purgatory and selling it to pay off the creditors. She's claiming through Saran Wrap that the court can't do that. We're claiming, heck yeah, the court can do that. Number one, because she did not want Otter Creek unincorporated. If you're in an incorporated town like Otter Creek, you can only homestead half an acre, which leaves 1.16 acres ready to be seized by the federal bankruptcy court, which they can do immediately right now. I mean, you're going to find out that Saran Wrap throws FLEASA under the bus and proves she's a pathological, manipulative liar, claiming that Kevin is actually trying to brokerage a deal with Turd Purgatory with me. And there's been many attempts on the trustee's end of things to try and sell me this property that I don't want. Nobody in their right mind is going to want a condemned, trashed piece of property. I've spent years cleaning up the ranch property, the school property. I don't know why people don't take care of their things. I don't know if it's a southern Levy County mentality that they don't take care of things. There are people there have beautiful properties. Belinda and Doug, gorgeous property. You got Ellie and Scott, gorgeous property. But there are others, they just trash everything. So she's claiming she's exempt, that the federal government can't seize the entire property. So the judge says, first thing we're going to do, I'm going to hear the objections of the debtor's claim of exemption. And specifically, that's docket 26 on this lawsuit, okay? And so Dennis, my lawyer, who's the specialist for creditors, says, Your Honor, I'm here, and our objection is really twofold. And I think we've gone over this objection so many times, I think everybody knows it per heart. The property was never legally homesteaded on the date when she filed bankruptcy. It's still not homesteaded. To have a homestead, you must have a legal, livable structure. She has neither. She has never had any. According to her, there are 3 homes on the property. According to Levy County, they were condemned. Therefore, they are not legal. They are not livable. According to her, she had a camper on the property. According to Levy County, And the federal bankruptcy court, that is not legal and that is not livable. Not to mention, they had that camper seized. Now they're in another camper, which is not legal and it's not livable. That is not an occupancy permit. A shed is not livable. No matter if you put kids in a shed, not livable or legal. A shelving, not livable, not legal by any stretch of the imagination. So Dennis says, hey, we have twofold objection. Property wasn't homesteaded at the date bankruptcy was filed. That's number one. And even if it was, it exceeds the legal half acre to homestead. So immediately you can seize the 1.16 acres right now, and we can fight about the half acre later. So there's a major thing going on behind the scenes right now. LIEnette has been fighting having inspectors come on the property. Inspectors need to come on the property, see what the property is actually valued at. There's never going to be a sale if we don't know what the actual value is. We don't know what they've destroyed on purpose, intentionally, knowing that the federal government is going to seize the property. We don't know what they're... Well, I say we don't know, but if you knows, you knows. We do know. All right, so Dennis says the parties have agreed to do an inspection. Now, you don't know this, but I'm going to share this with you now. Saran Wrap and Randy have been in conversation, and this is public now, it's on the public record, about inspections, and LIEnette is adamant that myself and Randy cannot be on that property. Now, that's going to be a major issue for an inspection when the federal bankruptcy court is trying to sell it to me. Multiple offerings going, here, we'll give it to you for this much. Here, this much, it's yours. Here. Who in their right mind buys a piece of property without inspecting it first? Oh, that's right. Fools, freaks, and felons who are out of their mind, who don't own mineral rights to their own property, who stalk people into towns claiming they have a life-threatening diseased child. That's who does that. This is going to be a major issue of contention because the trustee wants me to purchase the property. The trustee continues to offer me the property, even to this day, and yet I've not been on the property to inspect the property. Now, I can smell the property. It's horrific. I can see the property. It is completely and totally trash. It is 100 times worse than it was before that horrific fence went up. You know, the one that's all warped, all bent up, falling down, jacking up the Jeep Gladiator that's going to be seized as well. Yeah, that's the one. So they want me to buy property. LIEnette doesn't want me or Randy on the property. By the way, the trustee isn't the only one that wants me to own the property. LIEnette wants me to buy the property. CROOK wants me to buy the property. Now, some may have heard FLEASA in the past few days actually referring to this. If it's about the property, I know all about it. That's not a bombshell. Oh, well, that's not the bombshell. Oh, but I can guarantee you it's nuclear. And nobody is in your corner, fatty. So, we'll keep going. And he says, even if it was homesteadable, there's still the whole issue of it wasn't when she filed. It's still not, and you're within the town limits, and we've got to figure this out. And there's going to be an inspection. There has been communication about an inspection. There's supposed to be an inspection within the next 10 days or so, which LIEnette has agreed to, under the conditions that she has time to clean. Now, let me define she needs time to clean. Hide assets. Oh, by the way, there's also the condition that any pictures that are taken by the inspector cannot be shared on social media. By the way, we don't agree to any of these conditions whatsoever. This is a public record in a public filing, in a public federal court case that she initiated. Every photo will be shared publicly. They are public information by very definition. And then Dennis also says we have another issue as well. We still have to take the full deposition of the debtor. And so there are facts surrounding this property that are pertinent to this issue. And as you may already know, that the debtor ran out of the last deposition. So we have issues that need to be resolved. Okay. So basically Dennis says if we're going to proceed, and by the way, there's supposed to be a final evidentiary hearing in bankruptcy court September 15th. Never going to happen. We're not even out of discovery. They haven't given discovery. There's still issues, fraud on the court. All right, so Dennis says if we're gonna be able to ever have a hearing to ever finalize this, we have a complete inspection and we have to have the complete deposition of the debtor. And then, and only then, can we actually be ready for a trial. So the judge goes, okay, Saran Wrap, what do you have to say? Well, actually, she goes, all right, Saran Wrap. Silence. He's not even... This guy ain't the brightest bulb in the pack by any stretch of the imagination. He's stuttering the entire time. He's not even communicating. He finally snaps out of it and starts communicating. And so she goes, all right, Saran Wrap. And Saran Wrap goes, Your Honor, I just want to simply say that I think this issue on the homesteading is a little bit bigger than just one piece of paper suggests. And he goes, we're not disputing that 1.16 acres is not legally homesteadable. Okay, he goes, we're not disputing that. We concede, we agree. She can't homestead, and the federal bankruptcy court can come in and seize 1.16 acres right now. He goes, that goes over the half-acre constitutional limitation. And we concede on all of that. We've conceded in our response in November. And he goes, I mean, he's stuttering the whole time. I'm trying to read what I wrote down. He goes, we produced the boundary survey to the trustee as well. And he goes, the real issue is the second grounds for their objection is denying the homestead because there's no livable structure. And that's their whole basis, is there was never a legal homestead. Even though Levy County has illegally homesteaded this for them, Levy County did this illegally. There is no legal livable structure. There never has been a legal livable structure while LIEnette and CROOK have owned this piece of property, which they will not own much longer. They will have nothing to their name extremely soon. And that's what happens if you want to play this game with stalking me. If you want to play this game with defaming me. If you want to lie about me. If you want to steal from me. I have no issue with anybody out there. You start something with me, though, I promise you I will see it to the end. And I don't care who you are. I don't care your age. I don't care your gender. I don't care your race. I don't care anything. You start a problem, I'm going to finish it for you. I don't start problems. I have no problem ending them. I am the solution in this particular case. So he goes, we've got the boundary surveys to the trustee. You know, this whole issue is there a livable structure? That's the crux of what we're going to be addressing at this September 15th hearing. And she's going, there's not going to be a September 15th hearing. What are you talking about? You're not even anywhere near the point of a September 15th hearing. So she literally goes, I wrote it down. She literally goes, from what I just heard from Mr. Levine, you're nowhere near ready to proceed on September 15th because discovery is not even being taken yet. And he goes, yes, Your Honor. I agree with you, Your Honor. Why she didn't light into him for discovery not being finished yet, I have no idea. I really thought this was going to happen. But this is a new judge, and she has case overload, and she's skimming through everything. She's not completely and totally engulfed in it yet, although I promise you she will be, and she's going to be frustrated with him. So she goes on to say, listen, this hearing on September 15th, the evidentiary hearing, it's not going to be an evidentiary hearing. We have discovery disputes that are outstanding. And she goes, all right, gentlemen, here's what's going to happen. We're going to have a status hearing on September 15th. That's what's going to happen. So on the objection of the exemption on the 15th, it's going to be status. We're going to find out where we're at. So in regards to that, she goes, is there any way that the parties can actually resolve some of these discovery disputes before then? Because that would really be nice if you guys actually just got along and took care of this. And if you're going to be at a point where you know how much time is needed to actually settle all of this stuff, to resolve all of it, let me know, because we can push things out. And she goes, let's get to the second motion to compel, which was docket 129. To compel discovery information. Now, we've got a lot of things out there, whether it be fat, toothless fleece of flea, with LIEnette still speaking on the record. That's an issue. She goes, I reviewed the motion, and I've seen that there's been so many additional documents that have been filed with the complete transcript in the motion to compel. And she goes on to say that, well, now we have the full transcript on the record. She literally mentions it's on the record now. The judge states, now that everybody has the full transcripts, here's what I want you to do. You have filed motions, you have filed things in the court system. I want it reformatted. Remember what I said before? She's a new judge with a huge caseload she just took on. She's not up to speed on everything, and she's doing the best she can. So what she needs is bullet points. She needs boom, 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 boom. She needs just the meat. Get rid of the sides. Give me the actual entree, is what she's saying. So she goes, now that you have the transcripts, let's do this. In the next 7 days, you both can file in regards to the issues that were happening in the deposition. And the alleged, she said, the alleged misconduct is what I wrote down. And so, but you have 5 pages each, no more. So you're going to go ahead, you're going to file again in regards to the misconduct alleged. And you're going to file what you said she did. Saran Wrap's going to go, no, she didn't. Even if she did, he still is paid, apparently by FLEASA, which is a great admission that's going to come up in bankruptcy court. I love it. When them gums keep flapping, I love it. Oh, the admissions. Oh, I love it. So she goes, 5 pages each. And what you're going to do is you're going to give me the excerpt from the transcript, and you're going to tell me exactly what page that excerpt is from, where the misconduct happened, and the line number. So if it was page 100, line 6, you're going to put the excerpt and go 100, line 6. And Randy goes, well, I already did that for you, except I need to reformat. And she goes, okay, just go ahead and reformat it, no more than 5 pages, and you have 7 days to do it. And she then goes on to say, blah, 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 blah. She never said that. I did, as I'm going through my notes. Okay. She goes on to say, listen, if there's a disagreement, also, she didn't say if, she said there's a disagreement also on whether this deposition was ended or suspended. Now, we already know that Randy suspended it, and then LIEnette ended it by running away. Randy was going to the judge's quarters. So she goes, listen, if you guys can figure this out, we don't need any more motions. We don't need any more filings. There's a disagreement, but you get 3-page limit. If you're gonna fight about this, you get a 3-page limit on what is actually going on, whether it was suspended or ended. And she goes, but if you guys can agree, you don't have to file anything. You guys can just continue on. Now, what I know already is that Saran Wrap and Randy have been agreeing on things. And LIEnette has agreed to continue her deposition under one condition. Randy's not the lawyer deposing her. She wants Dennis Levine. And that's not happening. There are no conditions. She is not in control. She may have filed this suit for Deuce, because Deuce was trying to save his own goose. Deuce used LIEnette to try and save himself. Now FLEASA is using LIEnette and Bankruptcy to try and save herself. And all of them are going down in a royal flush. Wait, what was that? Slam dunk, hashtag aces high, hashtag you ain't got no teeth, hashtag Gaby is in jail, hashtag your life sucks, hashtag you're jealous, hashtag nobody likes you, hashtag you might want to change, hashtag there's no hope for you though. So we're told 3-page limit. And Randy then says, hey, Judge, that's okay. We actually are already in agreement. We've been talking about these things. We've spoken. And Judge goes, that's wonderful. I like to hear that. And he goes, we have a date. But my client is not going to allow anybody else to depose her except for me. And that's his legal right. And that's who's going to do the deposition. And he goes, I think there's a little bit of an issue based on the history with this LIEnette and the opposition and the vitality, the pure evilness that exudes from her during these depositions. He goes, my client has a right, legal right, of any attorney of his choice to run this deposition. And he's already told me it's going to be me and nobody else. And that's what I have told him. And so Saran Wrap jumps in and goes, yes, we have been speaking and we have been agreeing. And there's a little bit of animosity. He used a different word. I can't remember what it was, but between the parties, animosity. You remember what it was? Deanna's over here. You remember what it was? She's a creditor as well. He said there's a level of, all right, she doesn't remember. Saran Wrap. Okay. When talking about,
I have it written.
With the depositions, with Randy running the depositions, there's a level of.
It started with the A.
It started with an A.
I gotta find it in my notes.
All right, she's looking. She's going through all her notes right now too. So, and he goes, I think it's being difficult to conduct. This is the best part. Saran Wrap goes, I'm not conceding that it was done in bad faith. Talking about the deposition of LIEnette where she runs out. He goes, I'm not conceding. He goes, I think it was an unpleasant experience for her. And he particularly says, but I don't think it was something done in bad faith. Referring to Randy. Saran Wrap is paid by FLEASA to represent LIEnette, obviously using money that was given to FLEASA that is 100% LIEnette and CROOK's money. Man, the fraud, the felonies. Oh, it's all gonna come to a closure. I promise you that. I can promise you that. And he says it was not something that Randy did in bad faith by any stretch. And the judge goes, this is good. I like to hear that you two are working together. And the judge goes, listen, if she doesn't want him to do the deposition, then you need to file something in court. But I don't have anything before me right now, and therefore it's going to keep going the way that it is, which, by the way, there's no way, even if they file something, that's just going to cost more money. There goes more money that LIEnette was supposed to get that FLEASA's holding on to and not giving over. And FLEASA admitting that she's paying it to Saran Wrap. Man, there is a huge ethical issue there. I'm not getting into it now. I promise you legality, we'll get into it later in the courts.
Acrimony.
Acrimony. That was the A word. Yeah. Acrimony. He said there's a level of acrimony
It
New
means
word.
Deep sense of anger, harshness, or bitter feelings.
Deep sense of anger, harshness, or bitter feelings. I've never heard the word before. That one was a new one for me.
You can spell it right, and I didn't know the word either.
Wow. Okay. Deanna spelled it in her notes right. Okay. And he goes on to say, she goes on to say, the judge, she goes, listen, if this is an issue, we're just going to schedule it right here in Gainesville. We will do it in my courtroom right here in Gainesville, to which I have my camera muted and I have my video muted. I put my video back on and I go in the camera to Randy and Dennis. Yes, yes, yes. I want it in the courtroom with the judge, her witnessing everything. I will be there. I will be in that courtroom. I will be there. And she goes, we'll do it here in the courtroom. And she goes, well, when we do it in the courtroom, we're going to have some scheduling issues. And actually, at one point, Randy goes, Judge, do you typically work in Gainesville? She goes, no, I'm in Tallahassee, but I can hear hearings in Gainesville as well. And she goes, but if we're going to do that, and if that's what it's going to come to, which I want more than anything, oh, I hope it comes to that. If we're going to do that, we're going to have to schedule this with the court system. We're going to have to get all of this taken care of. She says we're going to have to clear it with the district court. We're going to be using their courtroom space. We're subject to their schedule. She goes, if this is what's needed, this is where we're headed. And if you reach out to my chambers, you let me know and we'll make this all happen. And I want this. I want this so bad. I want LIEnette deposed in front of this judge in the court in Gainesville. That's all I want for Christmas. LIEnette wants teeth. FLEASA wants teeth. I want LIEnette deposed in front of the judge. Judge goes on to say, well, figures, or it looks like you guys have figured out this whole deposition thing. So you don't have to submit a 3-page motion or anything on the docket unless you can't resolve it. But it looks like you are going to resolve it. And then she goes, all right, Kevin and Mr. Levine, do you want to add anything else to any of these matters? And Dennis Levine goes, Your Honor, there's just no way that this scheduled hearing on September 15th is going to happen. We don't even know if she's going to show up for the next scheduled deposition. She hasn't in the past. So we should probably push off the September 15th hearing to later in September, to the end of September. And it's just a suggestion, which the judge goes, well, I'd like to hear whether you guys have actually reached an agreement yet or not. If you're going to conduct the deposition, if it's going to be in Gainesville, because if not, we're going to have to find a time and a place, and it's going to be here with me. And I'm going to have to rearrange it. So I'm keeping this on the docket. September 15th, we're going to have a status hearing, and we're going to know what exactly is going on so we can continue to move forward. It's not going to be at the evidentiary hearing. It is going to be a status hearing now. Dennis, Randy, here we go. Okay. We're still going to meet on the 15th, which then she goes, Kevin, do you have anything to add to this? She goes, the court's aware that the trustee did join the objection based on the creditor, Jeremy Hales, that the property exceeds the half-acre limit for homesteading. In other words, the federal bankruptcy court is seizing. They can sell it right now. They're seizing 1.16 acres. It's a done deal. They're taking it. They are taking it, they are selling it, they're using the money to pay off the creditors. Me. Wait, hold a second. Wasn't it that fat, toothless flea that said, I'm more of a creditor than he'll ever be? And then filed public documents stating she's not even a part of this case. And then came back and said that she's a creditor again. So she's a creditor in the case. Files public legal documents stating she's not a creditor, then publicly online says she's a creditor again. Who's lying? And why would anybody ever listen to the vile vomit that comes out of her pile? She's in trouble, and she's scrambling, and she's scared. Very, very, and she should be. Should she ever? And so Kevin goes, we agree. We join them in the objection. That is not homesteaded property. And then he goes, but the half acre in the aspect of whether there was an actual livable and legal structure, we have no position. In other words, the trustee is letting me fund and fight it instead of them wasting time and money on their own. That's what it comes down to. Trustee knows there's no livable structure. They're just letting me fund the lawyers and the lawsuit so that they don't have to. Because if they don't have to, that's less money that comes out of... It's a money thing. That's what it comes down to. Okay. And then the judge comes back and says, all right, just so we're all clear, here's where we're at. That we're going to continue the motion and the second motion to compel. That's going to all be continued. And the objection to the debtor's claim of exemption. That is all going to be continued to the status hearing. And if we got to go to Gainesville, we're going to Gainesville. So nobody has to write a 3-page note or motion anymore in regards to the deposition because everybody's agreeing and hopefully it goes to Gainesville. But everybody has to write a 5-page in regards to the other referenced things. And she says, all right, you got 7 days for the 5-pager. And we're going to have the status conference on the 15th instead. She goes, oh, and I reviewed Saran Wrap. I reviewed your motion to dismiss. This was very, very interesting. She goes, I reviewed your motion to dismiss. And she goes, and based on the pleadings filed in case law, you fail to meet the Twombly plausible standard, and therefore, your motion to dismiss must be dismissed. In other words, denied, thrown out. Now she goes, for that reason and for others that are going to follow here, I'm going to deny the motion to dismiss without prejudice, with leave, and you have 21 days to amend and refile again. Now, you understand, we're telling the court LIEnette has committed fraud. She's not sharing everything as far as assets. And in response, Saran Wrap is going, no, dismiss. This is all wrong. And the court right now is going, no, it's right. And you're going to get one more chance. You have 21 days to amend your motion to dismiss saying that it's wrong. And she does go on to say, I want to point out some things. You know, if the court is going to enter an order on this, therefore neither lawyer has to write up the order. So it's very common for the judge to have the lawyers write up the order once they make the order. And then they go over the order, they make any adjustments, any changes, and then the order becomes a legal document. She goes, the court's actually going to write up the order on this one. I'm going to do this one. And she says, it appears that... I didn't even understand this part. In reference to 727A2 and 727A4, she goes, I don't even think there's a way for the defendants to know that the cause of action is actually being pursued. I got lost in this. I didn't understand exactly what was going on there. And there's so many intricacies, which is why I have lawyers doing this for me. I need to spend my time generating income so that we can have impact on people's lives, while the lawyers are fighting these battles for me. So I don't get it all. But she does go on to say that there's going to be, in the motion to dismiss, there has to be the plaintiffs must assert who, what, where, when, and the purported fraud. And she goes on, the creditor needs to demonstrate that the debtor knowingly and fraudulently made false oath relating to material fact. Well, we have more than enough evidence in regards to proving that LIEnette continues under oath to lie about assets, about fraud, and she is frauding. Wait. That would be defrauding the federal court. And the judge goes, it's unclear that the alleged non-disclosures were material fact or just errors. In other words, we're going to have a hearing about this. Is LIEnette intentionally, willingly knowingly, maliciously lying. You could answer that one already, right? LIEnette and CROOK are intentionally, maliciously, knowingly, willingly lying to that fat, toothless flea right now. They are doing everything they can to get every penny out of her and put her in jail forever. I'm quoting their words, verbatim. Are you ready for fat, toothless FLEASA's lies to be exposed yet again? I hope you are, because it's about to happen. The judge says, I see no joint report has been filed in this case either. And everybody goes, no, there hasn't been. She goes, have the parties conferred at all on this case, or has it been on hold pending the resolution of this motion to dismiss? Saran Wrap goes, no. She goes, Your Honor, this is Saran Wrap. Saran Wrap states this. You know, the one that FLEASA says she just paid and he works for her and he's loyal to her, which would be a huge ethical conflict of interest for this lawyer. A lawyer, no matter where the money comes from, is loyal only to the client they represent, period. And I can assure you, he is not loyal to fat, toothless FLEASA. I have it in writing. Won't be shared today. It will be shared in the future. He says, no, Your Honor. I can represent, listen closely, that there have been substantive settlement talks occurring. The trustee seems to sort of be brokering the arrangement between us and perhaps Mr. Hales as well by the virtue of settlement talks. They're underway. So I don't even think there's a possibility this could be, or he says, I think there's a possibility this will be resolved and the parties won't even need to agree to mediation. Or she asked later, are they agreeable to mediation? Saran Wrap on the record in court just implodes FLEASA's lies. I've stated multiple times that the trustee have come to me with offers they want me to buy the property. I have thus, to this date, turned down every offer. Now, since it's on the public record, and I didn't make it public, and I didn't want it to be public, there is another offer on the table. And there are some massive, massive contingencies to that offer. They have brought me yet another offer. And when I say massive, we're talking walrus-sized contingencies. That didn't come from me. LIEnette and CROOK. Tick, tick. Boom, baby. The judge then states, well, would mediation be okay? Would we need mediation, a settlement conference? And Dennis Levine goes, listen, Judge, too soon. We're just nowhere near that. I mean, all we are getting thus far is opposition. So she agrees, and then they start talking scheduling. And Dennis says, listen, my experience here in bankruptcy court, we're absolutely going to see another motion to dismiss. You just gave 21 days to Saran Wrap to draft another motion to dismiss. We're going to see it. That's going to get a hearing. It's like we're nowhere near that point. And the judge goes on to say, okay, well, I'm going to wait for the amended complaint to get filed. I'm going to wait and see if the motion to dismiss is filed. And she goes, I will tell you, gentlemen, I think it was a close case as to whether to grant the motion to dismiss on the 2 counts. Now, I don't remember what that all entails. I don't remember the complaint completely. So I would have to pull that up, and there's just so many things. I can't recall. But if you're one that likes to dig in deeper, you can go back and pull up these documents and find out what she was actually referring to. She then states publicly on the record, I don't know that a second motion to dismiss, this would be Saran Wrap's responsibility to file on behalf of LIEnette. I don't know if a second motion to dismiss would be well-founded. In other words, she's saying, you want to spend the money to actually file another motion to dismiss is going to be denied again. She's outright telling him, you do this again. She doesn't say it that way. She says it in a judge polite way that it would not be well-founded. And she goes, but you know what? I'll wait. And then I'll reserve my ruling when I see one, if I see one. And then talks are of the next hearing, the status hearing, September 15th. It goes from 1:30 to 10:30. So let's see, what happened today? FLEASA got called out by Saran Wrap as the biggest, fattest liar out there. We now know that the trustee is in yet another negotiation settlement with me in regard to turd purgatory. And I'm sharing with you some of the contingencies have nothing to do with me, have nothing to do with LIEnette or CROOK. LIEnette and CROOK are specifically putting in contingencies about FLEASA. Oh, did Saran Wrap forget to mention that? The one who's so loyal to you? Why would LIEnette and CROOK put legal contingencies in a federal court about FLEASA? Tick, tick, boom, baby.